Good morning. Before we begin, I would like to remind our spectators that their microphones should remain off at all times. For judges and participants, please keep your cameras on and your microphones should only be on when you're speaking. All present. Session W1 of the Walker-Moot Supreme Court is now in session. It is with great honor and privilege that I present Justice Kirsten Craig of BLG, Grant Ferguson of Steiberg Burlach LLP, Masha Debarian of Bogarash Associates LLP, and Hootie Kraus of LMS Lawyers. Presiding. Justices of the panel, I present to you, speaking on behalf of the appellant, Ms. Armstrong, in today's matter before the court, Alexis MacLachlan and Stephanie Morris. And speaking on behalf of the respondent, Dr. Ward, Iman Nasrallah, and Lyle Mounzer. We are here today to determine the outcomes on appeal before the court on the matter between Ms. Armstrong and Dr. Ward. Both the appellant and the respondent's counsel will have 30 minutes each in total, 15 minutes each counsel member to present their arguments to the court, including answering questions from the bench. The appellants will present their argument first, followed by the respondents, and then a 3-minute rebuttal period will follow by the appellant. I will signal to the court when there is 5 minutes left per speaker. Appellants, will you be using your 3-minute rebuttal period today?
Yes, please.
Wonderful, thank you. And when the 5 minutes are up, I'll post this little backwards now 5 and a 0 when the time's elapsed. The court now invites counsel for the appellant to begin.
Justices of the Walker Supreme Moot Court, good morning. As my friend Ella said, my name is Alexis and my co-counsel is Stephanie Morris. We're here today on behalf of the appellant, Ms. Karen Armstrong. As you're aware, this action arises from an injury that the appellant sustained during a laparoscopic colectomy performed by the respondent in February of 2010. On this appeal, we urge this court to restore the trial judge's ruling, and the reasons for our position are as follows. First, we submit that the trial judge properly formulated the standard of care as one of reasonableness. Second, it was appropriate for the trial judge to consider causation as evidence to inform whether the respondent fell below the standard of care. Third, the plaintiff only has the duty to rule out non-negligent causes raised at trial. And lastly, the appeal court should have reviewed the trial judge's decision for reasonableness instead of correctness. I'll be discussing the issues of the standard of care and causation, whereas Ms. Morris is going to be talking to you about the duty to rule out non-negligent causes and the appropriate standard of review that the majority should have applied. I'll start by discussing the correct standard of care to be applied to this case before I move on to causation. There are 2 points that I want to address regarding the standard of care. First, the standard of care articulated by the trial judge was not a standard of perfection. Second, the standard of care did not focus on the goal or the result to be achieved, but rather the steps that the respondent should have taken to meet the requisite standard. Our friends will likely argue that the standard of care set by the trial judge was a standard of perfection, and we respectfully disagree. The trial judge correctly formulated the standard of care based on uniform evidence about what a reasonable and prudent surgeon would have done and should have done when operating on a benign colon. As we know, the standard of care for a medical practitioner, as articulated in Kritz and Sylvester, is to exercise that degree of care and skill which could reasonably be expected of a normal, prudent practitioner of the same experience and standing. An unfortunate outcome does not constitute proof of negligence. The trial judge instead needs to look at the expert evidence presented at trial and decide what could be expected of a reasonable practitioner in the same circumstances. We submit that this was a case where there was no one, none of the parties and none of the experts who even suggested that there were any circumstances in which a surgeon might not be able to maintain a safe distance from the ureter while using the ligature. This was simply not argued at all at trial. The respondent testified that he believed he had indeed succeeded in staying 5 to 15 centimeters away from the ureter while using the ligature. All of the experts who provided an opinion on the standard of care agreed that to meet the standard while operating on a benign colon, one had to identify and protect the ureter, but also stay at least 2 millimeters away from the ureter while using the ligature. This last step is the one that the respondent failed to take. I mentioned that the appellant's colon was benign because this is relevant to the context in which the trial judge defined the standard of care. The experts testified that it's not difficult to identify and protect the ureter unless the anatomy is obscured, when risk factors like large pelvic masses, inflammatory disease, radiation therapy, etc., are present. But in the absence of those anatomical obstructions, like in this case, the surgeon should have no issue staying away. It would be unusual to be that close without any pathologies forcing them to be. The respondent agreed that it was an error to use the ligature within 2 millimeters of the ureter, but denied that it would be a breach of the standard of care. During cross-examination, he was asked, if you did use the ligature within 2 millimeters of the ureter, if you did it and you still don't know if you did it, that was an error on your part. Do you agree with that? To which he responded, I agree. The respondent's expert, Dr. Hagen, also agreed that there's no risk of injury to the patient's ureter when this procedure is performed properly because the surgeon is centimeters away. In his own words, he said, it's not possible to damage the ureter if you've identified it. Dr. Robinette, also the respondent's expert, was cross-examined on his standard of care report. He agreed with Dr. Hagen that the standard of care was to find the ureter and then stay away from it, far enough away from it, so that your instruments don't inadvertently damage it. He agreed that if the respondent inadvertently used the ligature within 2 millimeters of the ureter, it was a breach of the standard of care. That's the respondent's own expert evidence.
Counsel, if I may ask a question.
Of course.
How do you address the potential risk of setting up a strict liability situation in that you are setting up a situation where coming within the 2 millimeters is essentially a de facto finding of negligence? And does that not then create a strict liability situation for you?
Thank you, counsel. We would submit that we are not suggesting that general surgeons can never come within 1 to 2 millimeters of the ureter while using the ligature. What our submission is, and what the trial judge found based on the evidence, is that in this optimal setting where there are no risk factors that obstruct the surgeon's view, it falls below the standard of care to use the ligature within 2 millimeters of the ureter, unless the doctor has a non-negligent explanation for doing so. So if the injury happens, but the doctor provides an explanation at trial to say, hey, there was an earthquake and I lost control, then it's not likely that the doctor is going to be found negligent. But as we know, that's not what happened here. The respondent testified that he was nowhere near the ureter. He believed he was 5 to 15 centimeters away. So this is different from strict or absolute liability cases, like where the doctor removes the wrong limb and liability automatically flows from the injury. In those cases, the doctor could not have followed the reasonable steps. In this case, and there are no opportunity for non-negligent causes to be presented, whereas in this case, there is that opportunity. And we know that the doctor attempted to provide a non-negligent cause as an explanation, but this was rejected by the trial judge. As such, the crucial step of staying 2 millimeters away from the ureter while using the ligature was not contentious. It was agreed by the experts that a reasonable, prudent general surgeon would do this during this basic surgery, as Dr. Hagen called it, while operating on a benign colon. It was a reasonable step that the respondent should have taken. It's not expecting a general surgeon to meet a standard of perfection. It's just holding him to the standard that the experts said a reasonable surgeon in his position would have met. Let's take a look at another example. Let's say a baseball player holding a baseball bat knows, and other equally qualified baseball players in the same circumstances agree, that if you swing the bat while someone is standing less than 2 feet away from you, you will injure them. Swinging a baseball bat is common. People do it all the time, all over the world. Baseball players agree it's a known risk that if they swing the bat while people are standing less than 2 feet away, they're likely to injure that person. So it's standard for baseball players to take steps to make sure that no one is standing that close before they swing the bat. But there are some conditions under which it's harder for the player to make sure that no one is standing within 2 feet. the player's view could be obstructed by something that comes between them and the other person. Like if the weather is bad and snow is coming down. Players all agree that it's more challenging to make sure that no one is standing within 2 feet if there's heavy snow, but if the conditions are clear, there's no reason not to be able to make sure that no one is standing that close. So if a player nonetheless on a bright, clear, sunny day swings the bat and hits someone, is it reasonable to say that they shouldn't have done so? Yeah, of course, everyone agrees. If there are no risk factors, nothing blocking their view, the baseball player should be able to swing the bat and keep it far enough away from people so that no one gets injured. That's what the evidence on this case supports, a finding that a reasonable, prudent general surgeon performing a basic surgery in an ideal setting should be able to identify, protect, and avoid direct contact with or close proximity to the ureter while using the ligature. We submit that this is a reasonable standard. It is not a standard of perfection. Furthermore, it's our submission that the trial judge did not set a result-oriented standard of care. An example of a standard that was found to be result-oriented was the one articulated in Faloka and Pinkertons of Canada Limited. In that case, the standard set by the trial judge did not say what it was that Pinkertons was supposed to do to prevent entry into the mine. There were 23 points of entry to the underground, and the trial judge found that Pinkertons did not meet the standard of care because they failed to properly guard the entrances, thereby permitting access to the mine. This standard of care was found by the Supreme Court of Canada to be flawed because it did not say what it was that Pinkertons was supposed to do to prevent entry, but failed to. But in this case, we know precisely what the respondent was supposed to do. It's what he thought he actually did, which was stay at least 2 millimeters away from the ureter. So we would argue that the trial judge did not err by setting the standard of care according to the result, but instead it was a reasonable standard that contemplated what the respondent should have done. It's also our position that describing protecting the ureter as a goal, like the majority did, is not helpful. We submit that trying to decide whether staying away from the ureter is a step or a goal muddies the water. Distinguishing between steps and goals in this case is just semantics. For instance, is making sure no one is standing next to you and swinging the baseball bat a step or a goal? Is operating on the proper patient a step or a goal? Is excising the proper organ a step or a goal? Is not burning the ureter with the ligature a step or a goal? If we were to distinguish between steps and goals, we would submit that staying away from the ureter should be considered a step that the experts agreed should be taken and that the respondent believed himself capable of taking. When asked if he takes any steps during the actual use of the ligature to protect against injury to the ureter, the respondent replied that he would take the step of ensuring you're several centimeters away from the obstruction before deploying the device. Justices, in my last few minutes, I want to leave you with our submission regarding the issue of using causation as circumstantial evidence to inform the standard of care. It's our submission that the trial judge correctly inquired into what happened to cause the appellant's injury before deciding whether the respondent fell below the standard of care. As we know, the parties argued conflicting theories about what happened during the procedure to cause the injury. So before being able to find whether the respondent breached the standard of care required of him, the trial judge had to inform that analysis with what the respondent actually did. We submit that the trial judge could not have properly decided whether or not the respondent fell below the standard of care without first examining the theories advanced by the parties about what caused the injury. Other cases from the Ontario Court of Appeal have affirmed that there are situations like the present where it's necessary for the trier of fact to take this approach. For example, in Maringalo and Oshawa General Hospital and Grass and Women's College Hospital, where the Court of Appeal overturned the trial decisions because they failed to examine what happened to cause the injury before deciding whether there was a breach of the standard of care. We submit that this case closely resembles those precedents because causation, or what happened during the procedure to cause the injury, was a critical trial issue in all of them. Furthermore, it might be suggested that if trial judges are permitted to inform the standard of care analysis with circumstantial evidence of causation, This could lead to a hindsight bias on the part of the judges, meaning trial judges will look backwards from the outcome to what the surgeon could have done to avoid it, instead of determining what steps were reasonable at the time. Although we submit this is an important consideration and something which could exist in these types of cases, this is an error that we believe can be avoided. First, in the majority of cases, it's not necessary for the trier of fact to take this approach. Usually, the trial judge can and should decide whether there was a breach of the standard of care without considering the injury. Second, we submit that the standard of care analysis in itself is not to be informed by causation, meaning the stage where the trial judge decides what the surgeon's responsibilities are is to be decided on its own. In this case, as we know, everyone was in agreement about those responsibilities. But defining the standard of care is separate from when the trial judge decides whether or not the standard of care was breached. For the second part, whether the surgeon met the standard of care, we submit that the answer to this question can be informed by circumstantial evidence of causation if necessary. And
Counsel?
Yes.
Sorry, if I may interrupt just for one more question. You raise on this point that the res ipsa doctrine is defunct, but isn't that essentially what you're arguing here? Is that by going with the causal analysis first and then informing standard of care, you're essentially using the result to define the standard of care consistent with res ipsa, but at the same time saying res ipsa no longer applies. How do you address that?
We would address that by saying that the standard of care that was defined, as I had previously alluded to, was that it refers to the reasonable steps to be taken instead of the result to be achieved. So if we were to deconstruct the standard of care articulated by the trial judge, I'm sorry, moderator, I acknowledge that I am out of time. I will just wrap this up quickly. So we would ask, is identifying the ureter a goal or a step? Is protecting the ureter by sweeping it away out of the surgical field a goal or a step? So as the majority defined a step, it was by executing an act that the surgeon is consciously able of doing. And so we would submit that the act of using the ligature 1 to 2 millimeters away from the ureter is a conscious step that the surgeon can do. So this is not the result or the goal to be achieved, and that's how we are avoiding the defunct principle of res ipsa loquitur. Thank you. I will now pass it over to Ms. Morris.
Thank you. Thank you to my co-counsel. I will now address the question, does the plaintiff have a duty to rule out non-negligent causes? It is our submission that the appellant did not have the duty to rule out all possible non-negligent causes, but rather that the appellant only had the duty to rule out those raised by the respondent and evidence at trial. At trial, Ms. Armstrong, as was her duty, established a prima facie case of negligence by providing expert evidence that the most likely cause of her injury was the negligent deployment of the ligature within less than 2 millimeters of the ureter on a balance of probabilities. Once this case was made, the onus then fell on the defendant to negate that evidence with an explanation of possible non-negligent causes of the injury, as per Fontaine in British Columbia. Dr. Ward's expert witnesses raised only one possible non-negligent cause, that the injury could have been caused by general inflammation to the retroperitoneum, meaning the cavity that holds the colon, due to use of the ligature during the surgery, and that inflammation in this area later led to necrosis and fibrosis, meaning dead tissue and scarring in the ureter. However, this explanation was rejected by the trial judge, and we submit that this was for good reason. As the Ontario Court of Appeal ruled in Hassan and Anvari, a trial judge is entitled to reject non-negligent causes based on evidence. Now I want to review Hassan and Anvari since it has some similarities to this case. It's a medical negligence where a patient's aorta was punctured by a surgeon during surgery. When the patient sued for negligence, the defense argued that because there was other possible explanations for the injury aside from negligence, the court was not entitled to draw an inference of negligence. The two possible non-negligent causes of the injury raised by the defense were that perhaps medical misadventure based on some unknown condition within the plaintiff's body had caused the injury, or that some other error had occurred that did not breach the standard of care. However, the court ruled that because the trial judge was alive to the alternative explanations when making a decision based on evidence, the trial judge's decision could not be overturned. In this case, the trial judge rejected the non-negligent explanation because the plaintiff's anatomy was normal, the sharp instrument used during the surgery was working properly, and there was some evidence that the doctor may have pushed too hard on the abdominal wall. So based on this precedent, an inference of negligence can be made if there are possible non-negligent causes, as long as a trier of fact is alive to the alternative explanations raised at trial and then rejects them based on evidence. And this is what the trial judge did in the case at hand. Dr. Robinette was the only expert witness who raised an alternative and potential non-negligent cause to our client's injury. The other experts disagreed that the injury could have been caused by inflammation to the retroperitoneum that later spread. Dr. Klotz disagreed. He said that there was no evidence of this type of injury. Dr. Bernstein disagreed, saying that if the ligature were to cause this kind of injury, it would be a device that haunts his practice. In his words, it's not normally seen, and I would say not ever seen. Even Dr. Robinette gave this explanation based on the assumption that the respondent had stayed 5 centimeters away from the ureter. He also said that this type of excessive fibrosis is not usually seen after this type of injury. So we see that the trial judge examined this evidence and rejected the non-negligent cause based on evidence, as was his prerogative. Now the respondent suggests that the trial judge is obliged to consider potential non-negligent causes, even if they're not raised at trial. And we disagree for 2 main reasons. First, defendants as medical practitioners are in the best possible position to bring forward alternative explanations and evidence for the injury. The defendant is most aware of what happened during the surgery and has prior experience and medical knowledge. Conversely, the patient is generally at a considerable disadvantage in trying to address all possible non-negligent causes, considering they may have been unconscious during the surgery and they likely do not have comparable medical knowledge. To put the onus on a plaintiff would require them to disprove endless possible alternatives and make it nearly impossible to prove medical negligence, which would bring the administration of justice into disrepute. For instance, should the appellant have to raise the possibility that the ureter moved due to natural bodily functions during the surgery? We submit that to require this would be illogical. Ms. Armstrong was unconscious, and any number of things could have happened within her body during the surgery of which she's not aware. However, the respondent is aware because he was conscious. Therefore, the onus should be on the respondent to raise alternatives, whether it be that the injury happened because of natural movement to the ureter, abnormal anatomy, a fire alarm going off in the building, an earthquake, or any other number of more remote possibilities.
Counsel?
Yes.
If I may interrupt you with a question. Isn't it up to the trial judge to be able to consider other non-negligent causes not raised by either party? And isn't that something that the trial judge in this case should have done, because he accepted that Dr. Ward did not touch the ureter directly with the ligature, but there may have been some other negligent causes you've mentioned, spontaneous movement, for example. Isn't it up to the trial judge to make that determination?
Thank you, Justice Ferguson. We submit that we agree with you. Absolutely, it was open to the trier of facts to look at all the evidence before him and then to examine alternatives if they were raised by the evidence. So not only those raised by the defendant, but those raised by the expert witnesses, which in this case, the explanation of inflammation in the retroperitoneum was raised by Dr. Robinette, one of the respondents experts. So if it is raised by the evidence and there is some suggestion that there could have been an alternative cause, then we would submit that it is in the trial judge's purview to examine it. But the one alternative cause that was raised was examined and was rejected based on the evidence. So that leads us to our second point for why trial judges should not be expected to rule on non-negligent causes for which there's no evidence, because to do so would be to overstep their jurisdiction as a trier of fact. It's long been established that the parties to litigation are entitled to a resolution of their differences on the basis of the issues presented in pleadings. Not to do so would be to deny either the plaintiff or the defendant the opportunity to address that issue in the evidence presented at trial. In an adversarial process, a judge is bound to make a determination of the issues on the basis of arguments and evidence before them, and to require a judge to go beyond this would be to overstep their role. So to conclude on this issue of non-negligent causes, the respondent could have presented other non-negligent causes as defenses. He could have argued that if he had come closer than 2 millimeters to the ureter, he did so non-negligently. The majority suggested that perhaps the ligature came too close to the ureter because of Dr. Ward's lack of dexterity or unexpected movement within the body. However, these arguments were never made by the respondent. The respondent only argued that he had not come within 5 centimeters of the ureter with the ligature. Neither Ms. Armstrong nor the trial judge have to go further in addressing non-negligent causes that Dr. Ward was not willing to make at trial and for which there was no evidentiary foundation. I'll turn briefly to the issue of standard of review. The respondent argues that the trial judge's decision was entitled to be reviewed for correctness by the Court of Appeal, and this argument was made on the assumption that the trial judge made an error in law related to the appropriate standard of care for a prudent surgeon. As my co-counsel said, we respectfully disagree with this position and argue that the trial judge did accurately articulate and apply the legal standard of care. Now, articulating a standard of care is a question of law reviewable for correctness. So did the trial judge accurately articulate the standard of care? If we look at the trial decision, as we did with my co-counsel, we can see that the trial judge did this. The trial judge wrote in his decision that he was looking for what a prudent surgeon should do and outlined other principles of finding a standard of care in medical negligence. The appeal court was right to review this part of the standard of care for correctness. However, after the standard was accurately laid out and it was determined that it was articulated properly, there was no error in law, and the majority should have applied the standard of review of reasonableness to review the findings of fact made by the trial judge on what is reasonable and prudent.
Sorry, counsel, may I interrupt again?
Yeah.
Thank you. So what I understand you to be saying is that the standard of correctness was correctly applied to the standard of care, but that once the majority had determined that the appropriate standard of care had been used, so they applied the standard of correctness, they should then move on to use a different standard. But the majority disagreed that on a standard of correctness, the trial judge had in fact applied the appropriate standard. So are you actually agreeing or disagreeing with the majority's approach in terms of the standard of care they apply?
Right, thank you. So we submit that the Court of Appeal should have reviewed the articulation of the standard of care. They should have looked at this decision to see if the trial judge took the appropriate case law for what a prudent general surgeon should do and articulated it so that what they were looking for really was reasonableness. And once they recognized that this was what the trial judge did, which is what he did in the first half of his decision, then the debate over whether this standard was applied accurately to the findings of fact is one of reasonableness, because facts should be reviewed for reasonableness. Findings of fact should be reviewed for reasonableness. Thank you. So reasonableness requires that findings of fact and inferences of fact should be given the highest degree of deference and overriding error. This could include ignoring conclusive or relevant evidence, misunderstanding the evidence, or drawing erroneous conclusions from it. So for instance, if the Court of Appeal found that the trial judge ignored evidence that there were instances when a prudent surgeon might not be able to stay away from the ureter When there are no risk factors, that would be a possible palpable and overriding error that could be reviewed. But as of yet, our friends have not made any direct reference to any palpable or overriding error in factual finding that would render the trial judge's decision unreasonable. We submit that if the appellate court had examined the trial judge's findings of fact for reasonableness, they would have found that he made reasonable findings of fact based on the evidence before him, and no reversible error would have been found. Justices, these are our submissions on the questions of non-negligence and standard of review. And in my last moments, I'd like to leave you with a summary of our positions and why we argue that the trial judge's decision should be restored. First, the trial judge used expert evidence to properly formulate a reasonable standard of care. Second, he necessarily had to inform this analysis of whether the respondent fell below the standard of care with what he actually did during the surgery. Third, once the appellant established a prima facie case of negligence, it was on the respondent to provide convincing non-negligent explanations for the injury, which the respondent did not do. And finally, since the Court of Appeal was reviewing a question of fact, they should have deferred to the trial judge's findings since no palpable or overriding error was made. Thank you.
Thank you, counsel. The court now invites counsel for the respondent to begin.
Good morning, Justice Crane, Justice Ferguson, Justice Krause, and Justice Deburian. My name is Iman Nasrallah, and along with my co-counsel, Layal Mounzer, we represent Dr. Ward, the respondent in this case. Today, I'll speak to three essential elements impacting the application of the standard of care in the present case. First, the standard of care is one of reasonableness, based on the medical practitioner's practice and experience. Second, the standard of care should not be based on results. And third, an accurate assessment of the standard of care cannot involve hindsight. My co-counsel will address the second and third issues regarding circumstantial causation and non-negligent causes. The proper identification and application of the standard of care is a question of mixed fact and law. To determine if a trial judge properly characterized the standard of care, the standard of review is correctness, which the Court of Appeal correctly applied. The standard of care in medical negligence cases is clear and non-controversial. It is well established in the medical field that the standard of care is that of a reasonably competent practitioner in the relevant field. The principle underlying this standard of care analysis is that healthcare providers should practice in accordance with the conduct of a prudent and diligent practitioner of the same qualifications under the same circumstances. Every medical practitioner must bring to his task a reasonable degree of skill and knowledge and must exercise a reasonable degree of care. This standard of care is outlined by the Court of Appeal in Kritz and Sylvester and was affirmed by the Supreme Court of Canada. The respondent urges this court to uphold the Court of Appeal's finding that the trial judge erred in defining the standard of care required by Dr. Ward. The trial judge made a series of compounding errors in coming to his decision. He combined the assessment of the standard of care issues with the causation analysis. Not only was this an error, but it also allowed the trial judge to work backwards rather than to first define the standard, whether there was a breach, and then relate causation to that breach. The elements of negligence are necessarily sequential. A breach of the standard of care is a prerequisite to causation. The nature of the standard of care and causation inquiries in particular make this clear. The causation inquiry is not intended to answer everything that happened to bring about the injury. Rather, it focuses solely on the fault-based behavior of the particular defendant. Without first identifying a breach of the standard of care, it's not possible to determine causation because there's no fault-based act or omission to potentially link the injury. As such, contrary to our friend's claim, based on the trial judge's finding, Dr. Ward was improperly held to a standard of perfection. Although our friends label it differently, the results are in fact analogous to a standard of perfection. Instead, the trial judge should have determined whether Dr. Ward performed the operation in a manner that a reasonably prudent surgeon would have done. The trial judge found that Dr. Ward took the necessary steps to identify and protect the ureter, which were the same steps that Dr. Armstrong's expert surgeon conceded a reasonably prudent surgeon would use. However, the trial judge did not identify any steps beyond those he found Dr. Ward to have taken to justify a breach in the standard of care.
Counsel, I have a question.
Yeah, go ahead.
Are you suggesting that it is never permissible to assess causation before standard of care?
Yes, Your Honor. There are certain times where my co-counsel will go through this in further detail, but circumstantial causation can sometimes be used. However, the standard of care, the negligence claim, is necessarily sequential. There are certain things that need to flow in order for a correct finding to be concluded. And in this case in particular, the breach needs to be related to the causation needs to be related to the breach and not the other way around, because doing so would go towards a finding in hindsight, which I'll go on to explain why is very risky in this case. Courts have actually repeatedly recognized that practitioners have an obligation of means, not an obligation of results. This is a result of the nuanced nature of medical treatment. Medical innovation has granted society countless benefits, but these advancements come in tandem with certain risks. Every advance in technique is also accompanied by risks, and any person receiving treatment is subject to risk no matter what level of care is provided. As cited in the Supreme Court of Canada in Wilcox and Cavan, the doctor is not a guarantor of the operation which he performs or the attention he gives. Allowing the outcome to influence the standard of care risks distorting the standard, which ultimately may improperly reverse the burden of proof, which speaks to your point, Justice Deberian. Mrs. Armstrong was aware of the facts that of the risks that were inherent to a laparoscopic procedure, which are higher than those done by way of open surgery in certain elements. Regardless, Ms. Armstrong accepted the risks in exchange for an advanced method of conducting her colectomy. It is therefore an error to hold a physician to the trial judge's standard, as no medical practitioner ensures achieving a perfect result. This rule was recently affirmed by the British Columbia Court of Appeal in Carlton and Sutherland, where the court overturned the trial judge's decision for imposing a standard of excellence that amounted to perfection and subsequently set a standard that was impossible to rebut. Similar to the present case, the trial judge improperly focused only on the result of the surgery and not on the precise manner in which Dr. Sutherland failed to meet the appropriate standard of care. As a result, go ahead.
Yeah, counsel, I'm sorry to interrupt you, but what I'm really struggling with here is how you meet your friend's argument that there was some kind of onus on the doctor to put evidence forward of a non-negligent cause of the injury, and how do you respond to that?
Mm-hmm. So in this case, I'll give you the example of defining the standard of care by goals and not means. So in this case, defining that standard by a goal does not inform the means through which a prudent surgeon would go about to achieve the required goal. In order for the trial judge's description and application of the requisite standard of care to apply, the trial judge would have had to distinguish the steps required from the steps that Dr. Ward took. Now, I know that your inquiry is focused on non-negligent causes, which my co-counsel will go into in further depth, but I will outline the structure for your question. So the trial judge in this case made no findings as to whether only negligent acts or omissions can lead the ligature within 2 millimeters from the ureter. Instead of asking whether Dr. Ward took the steps a reasonable, prudent surgeon would have taken, the trial judge measured Dr. Ward's negligence by determining whether he came within 2 millimeters of Miss Armstrong's ureter with the ligature. The correct course of action, as agreed upon by both Dr. Ward and Dr. Hagen, who operate laparoscopically and have extensive experience using the ligature, is that a medical practitioner should intend to keep the ligature far away from the ureter. Instead, the standard of care suggested by the trial judge suggests that any deployment, whether intentional or accidental, breaches the standard of care. In reality, avoiding accidental deployment within 2 millimeters of the ureter cannot fairly be described as a step that prudent surgeons take. As stated by the Court of Appeal, instead, it's a goal to be pursued. In other words, trying to maintain a safe distance is a step that one takes, and successfully achieving that is the goal. The expert witnesses provided they provided the trial judge with detailed evidence about the steps that a prudent surgeon would take to identify and protect the ureter. The trial judge accepted that evidence and was satisfied that Dr. Ward took steps during the surgery to identify and protect the ureter. He explained those steps and testified that he always kept at least 5 centimeters from the ureter. Despite finding that Dr. Ward took the steps of a reasonable and prudent surgeon, the trial judge predicated liability on the results. Precisely, Dr. Ward coming within 2 millimeters of the ureter. This evidence demonstrated that Dr. Ward carried out the surgery in accordance with a reasonable approach. So the trial judge turned to the result to find liability, which the Court of Appeal characterizes as a conclusion, as an error on his part. Had the trial judge properly applied the law to the facts he found, Dr. Ward would in fact have been free from liability. Where the standard of care is informed by a goal of avoiding injury, the standard is heightened to one of strict or absolute liability, since liability follows with every injury. Needless to say, this is an improper measure of liability in medical negligence cases, as courts have previously recognized that the law does not usually imply a warranty that a professional will achieve the desired results, but only a term that the doctor will use reasonable care and skill. Relying on causation to begin the analysis led the trial judge to reason based on hindsight and results, which allowed the trial judge to impose a standard of perfection on Dr. Ward. Misadventure is inevitable because of the reality that perfection in all cases is unachievable. For this reason, a core principle of professional negligence law is that one cannot reason backwards from an adverse outcome, implicitly assuming that if something went wrong, then someone must be to blame. In substance, that is what the trial judge did exactly, defining the requisite standard of care as not causing an adverse outcome. Instead, the correct approach is determining whether the surgeon acted reasonably in the technique employed in carrying out the surgery. In this case, identifying and protecting the ureter. This was not used to define the standard nor to assess the breach. Respectfully, while our friends make a distinction between steps and results, their claim is contrary to that provided by the expert witnesses. The rhetorical questions that they raise do not assist the court in making a determination on the required standard of care. Where identification and protection were considered, the trial judge found that Dr. Ward had in fact met the standard. However, because the trial judge infused his definition of the standard of care with his determination as to what caused the injury, the trial judge still found a breach of the standard. In conclusion, the law on the standard of care required in medical contexts is clear and has been well defined for decades. Had the trial judge properly applied the law to the facts he found, Dr. Ward would have been free from liability. The Court of Appeal correctly reversed the decision on the basis that the trial judge solely relied on the injury, which led him to a determination based on results and improper reasoning, and affirmed that established medical negligence law must be appropriately defined by the trial judge and the standard to identify the breach. Subject to any questions, those are my submissions. My co-counsel will now address the issues of circumstantial causation and non-negligent causes.
Thank you. Good morning, Justices. As my co-counsel laid out, I will be discussing two issues today. I will first discuss when, if ever, causation can be used as circumstantial evidence to inform the standard of care. I will then move on to the question of whether the trial judge had an obligation to rule out non-negligent causes. And I'd like to begin by pointing out that these two arguments only flow if you accept the respondent's first submission that the trial judge did in fact err by working backwards from a results-based assessment that to then arrive at the standard of care. To the first issue, the respondent submits that causation can be used in exceptional circumstances as circumstantial evidence to assess whether there was a breach of the standard of care, but not to define the standard of care. The sequential negligence test articulates the general rule that standard of care must first be defined, a breach then be found, and then the issue of causation discussed. And the respondent does concede that there are exceptions, and there are some cases that do demand a determination of what happened, that causation inquiry, when assessing the standard of care. But again, this is assessing whether there was a breach, not defining the standard of care. And as the Court of Appeals stated, the respondent agrees that where the nature of the injury is relevant to what happened, it is not an error to consider the circumstantial evidence in resolving whether there was a breach. It is not relevant, however, when defining the standard. In Marangolo versus Oshawa General Hospital, as well as in Grass litigation, there was a need to determine what happened. But in both cases, the standard of care was defined prior to discussing this causation. The causation, what happened, was only used as circumstantial evidence to determine whether there was, based on a defined standard of care, a breach of the standard. So I'll take you through those two cases fairly quickly. In Marangolo, the first step was the trial judge defining that the standard of care in a bronchoscopy is monitoring the patient according to three specific requirements. So what happened, the brain damage, and the circumstantial evidence led to this inquiry was the defendant doctor's actual actions during the procedure to determine whether he did follow those three requirements in monitoring the patient. And this was an appropriate assessment of causation, and this did inform that he did in fact breach that standard of care, but the standard of care had already been defined. Similarly, in Grass litigation, the standard of care was first defined as the doctor making a judgment call to transition from a vaginal delivery to a cesarean, and the risk to be avoided here was applying excessive pressure with the forceps to the newborn's head. The Court of Appeal found that the circumstantial evidence was necessary to assess whether the appropriate type and amount of force of the forceps used was in fact subject to the standard, since not doing so would be a breach of it. The plaintiffs were entitled to this conclusive finding of factual causation to assess whether the doctor breached the standard of care by applying that excessive force with the forceps, but the already defined standard of care with a judgment call being made so as not to do that. And so the trial judge's error in the case at hand, when he was conflating the standard of care with causation, actually flows from his incorrect application of the standard of care. And it's because he worked backwards from this results-based assessment, he found that he did need to explore what happened to inform the standard of care. And he arrived at the standard of care being avoiding close proximity of 1 to 2 millimeters or direct contact with the ureter. So the trial judge's analysis can be summarized sequentially in the following way. First, his first conclusion was that the possible range of thermal spread with the ligature is 1 to 2 millimeters, and that the ureter would be injured if it came within that range of thermal spread. He then concludes that since the ureter was injured, Dr. Ward must have brought the ligature within 1 to 2 millimeters. He then reasons that the standard care is to avoid close proximity, which is 1 to 2 millimeters, or direct contact with the ureter. By effect, injuring the ureter was a breach of the standard of care. Now, had he employed the correct standard of care analysis, the trial judge would have began at defining the standard of care based on steps that a reasonable prudent surgeon would take. And then when he got to assessing whether Dr. Ward breached this standard, he was entitled, and the appellants were entitled, to lead circumstantial evidence and to find a factual causation as to the events that transpired during the surgery.
Counsel?
To inform whether there was a breach.
Excuse me, counsel?
Yes.
If I may ask a question on that point, isn't it also within the trial judge's discretion to have determined that the standard of care was not to breach that 1 to 2 millimeter distance? And so causation doesn't define the standard of care, but rather it merely informs a incomplete standard of care. Isn't it up to the trial judge to make that determination that simply a fact like coming within 1 to 2 millimeters is sufficient to breach the standard of care in this case?
Yes, so that would go back to the issue of defining the standard of care that my co-counsel has talked about in terms of a goal. So in this case, the trial judge was entitled to accept the expert evidence as to what the steps would take, the steps that a reasonable prudent surgeon would take, and the steps to avoid. So this is the risk that we're talking about, the risk of coming within 1 to 2 millimeters, and that is the risk of injury to be avoided. But the steps to take that is to check and recheck. That would have been a reasonable step to make sure that the ureter and the other organs are out of the field of surgical view. And so that your question, Justice, goes back to more kind of the 1 to 2 millimeters being inappropriately positioned as a goal, and that informing the standard of care, whereas it actually should have been the steps. Okay. So in conclusion, on this point, we submit that a determination of what happened during the procedure is, in exceptional circumstances, relevant to assess whether there was a breach of the standard of care. The trial judge's error in this case was employing this causation analysis to define the standard of care. I will now turn to the issue of ruling out non-negligent causes. The respondent submits that because the appellant is framing their case as the occurrence of an injury is negligence, they do have the obligation to lead, and the trial judge must consider that this could only be the result of a negligent slip. And contrary to what our friends were saying, the majority are not creating or overturning an existing law. What they are doing is narrowing the circumstances when it is permissible to inform the standard of care as an injury. So now our best starting point on this discussion would be the reasons of the Court of Appeal at paragraph 42. And they start the discussion by saying that they are not ruling out that there are cases where negligence alone could prevent a goal from being achieved or a positive result from being attained. But where the systems in place to prevent those injuries are so robust that the injury could only be possible through negligence, it would be harmless to define the standard of care as an injury. And an example of this would be, don't leave the sponge in the patient. Don't cut off the wrong limb. Ruling out non-negligence causes is not a matter of fishing outside of the record. It is actually simply assessing the sufficiency of the evidence that this was a negligent slip. And again, we are limiting this inquiry to the cause of why the ligature came within 1 to 2 millimeters.
And the respondent submits that if we are to define the standard of care by the strict liabilities that the trial judge defined it by, then we are saying that in every instance where a surgeon comes within 1 to 2 millimeters, this is an automatic breach of the standard of care and a negligent slip. And so where the trial judge is defining the standard of care as such, he must be able to make a finding that negligence is the only possible cause. And it is the plaintiff's obligation to leave that evidence. Because if the plaintiff's case is that causing the injury is negligent, then the onus is on them. And contrary as well, considering what our friends were saying, this does not place an impossible burden on the plaintiff. The plaintiff can always lead expert evidence to pinpoint this particular act or omission, which is what negligence is, what constitutes negligence, rather than prove this in the negative by leading endless potential causes. That's not what is being asked of the appellant. So that concludes my submissions on this point. And in conclusion, because the plaintiff forms their case as causing the injury is negligent, the trial judge does have to be satisfied this could only occur negligently. And the respondent submits that on this record, the evidence, which would have been led by the appellant, is insufficient. So in conclusion, the respondent submits the following: that the trial judge erred in defining a standard of care by an unfortunate result, as opposed to the steps that a reasonable, prudent surgeon would take. Dr. Ward, a medical practitioner, cannot be held to a standard of perfection. Second, the trial judge erred in considering causation as circumstantial evidence because he used it to define the standard of care rather than assess whether there was a breach. And finally, because the appellant proceeds on the basis that causing this injury is negligent, they do have an obligation to lead and the trial judge to be satisfied that the only possible cause of the injury could have been negligence. Subject to any questions, that concludes my submission.
Thank you, counsel. You spoke about goals and goals and steps, and I'd like you to clarify for me, are steps part of reaching goals? Are goals part of each step?
Correct. I think it's very easy to conflate the two, and in some circumstances, like I said, do not leave the sponge in the patient. That is a step, but also a goal, because the systems are set up in such a way that it should be a breach of the standard of care to leave a sponge in the patient. However, in a medical procedure that is complex and has multiple steps, where one of the steps, for example, is you have to sweep the ureter and other organs to the top of the abdomen in order to see what is going on and keep them out of the range of that ligature. That is a step, but actually avoiding injury is a goal. And one of the steps can also be to constantly recheck and make sure that those organs are still being held in place and that they are not coming back into that surgical field of view within the thermal spread range. The goal here is to avoid burning any one of those organs, the ureter, the liver. So that is a goal, not the goal of the surgery, but that is a goal, whereas the steps are to recheck and do that at the beginning, make sure that they are held in place.
Just one other question is you made the comparison between this and other surgeries, and you alluded that this was a more complicated surgery. The opposing party made the imposition that this was a simple surgery. What is your position? Just to clarify.
So when I say complex, I mean that there are a series of steps. So I think any surgery would be complex. There are ones that are done daily by the same surgeon that are done around the world. Those are considered simple just because the technologies that we have and the experience that these surgeons have in performing them is so extensive that they are surgery 101, I believe it was called. But when I say complex, I mean it in the sense that there are steps that the surgeon has to take to get to his goal and in performing the procedure.
Okay, thank you.
Thank you.
Thank you, counsel. The court now invites counsel for the appellate to begin their 3-minute rebuttal.
Thank you. We would like to provide a rebuttal to 3 of our friends' submissions. First, our friends suggest that the trial judge erroneously conflated the breach of the standard of care analysis and causation. However, the majority actually conceded that taking this approach is not an error, and that there are situations in which it's appropriate and necessary. The reason why the majority disagreed with the trial judge's approach is because they opined that the standard of care was incorrectly defined. But in our submission, the trial judge properly formulated the standard of care pursuant to the combined uniform evidence presented by the experts at trial. The standard of care was not a contentious trial issue. As such, we submit, given that the trial judge properly articulated the standard of care, it was not an error to inform the breach of the standard of care analysis with circumstantial evidence of causation. Second, our friends indicated that the questions of mixed fact and law are reviewable for correctness. We submit that the case law suggests differently. In Hewson and Nicolaisen, a Supreme Court of Canada decision, the court found that findings of negligence and standard of care are questions of mixed fact and law. And as per Hewson, there is a section of this analysis that is subject to a correctness analysis. That section is the articulation of the standard of care, or in other words, the standard of a reasonable prudent surgeon. The factual part is how the standard is applied to the facts at hand. That is the only section that is reviewable for reasonableness, which means overriding and palpable error. Lastly, if the standard of care were to be defined by the steps suggested by our friends, that the standard should only be to identify and protect the ureter, we submit that the trial judge would have fell to the error previously mentioned in Faloka and Pinkertons of Canada Limited, where the standard of care lacked specificity. If the standard was to identify and protect the ureter, the next logical question is, how can that be done? Well, the only way to do so is by staying 1 to 2 millimeters away from the ureter while using the ligature. As such, it's our submission that the trial judge correctly defined the requisite standard. Thank you, Justices. This concludes our rebuttal.
Thank you, counsel. This concludes the matter of Armstrong and Ward. At this point, I'd like to remind our judges to send their score sheets according to the judges' briefs. And that concludes today's session. I invite you to stay for the second